like, look, I don't even know of an attorney that would answer that question without getting himself in trouble.
Right.
I said, I can't tell you what to do. You know, that's why I wrote the book. I said, because if the book, if there's something in there for you, any little nugget that will help you make a decision, it's on your conscience.
Right.
So you basically have to decide whether or not you're going to fight or flight. If you're going to run, then restructure your life. This is what a lot of people have been doing. They've been staying in their houses, literally hiring an attorney to do nothing but stave off the wolves.
Right.
And so they'll stay in their house for a year and a half, 2 years without making a mortgage payment. They'll pay the attorney a mere pittance of what their mortgage payment is.
Sure.
They will take all their money and accumulate it and then go somewhere else and buy for cash. Or they'll rent. You know, a lot of people that did, you know, we've talked about this before because I'm not totally, I understand the purpose of banks and why they're there, and not all banks are bad. I have to say that. You know, it's not a disclaimer, but I happen to know I work with some good banks and banks that do care. I actually talked to a bank's attorney when I asked him, can you fix a chain of title that's been totally trashed by this kind of a scenario? And he said, absolutely not. You cannot fix a chain of title other than to quiet it. And that's why we have what we call quiet title actions.
Okay.
And this is where you go into court and you basically put it out there to through publication and by direct service of the people you know and publication for the people you don't know. And you use the quiet title action to bring everybody into court. And a lot of attorneys are coupling this with a declaratory judgment action, which basically puts the burden of proof on them when they come into court. They have to actually prove that they own it.
Right.
I got the paperwork right here, Your Honor.
Which is what people weren't doing before. They were just not answering the mail or doing anything, and then it's a default judgment. And then it doesn't matter if you were right or wrong. The judge is going to give it to the bank anyway.
Exactly. Well, and see, if you don't fight and you don't get an attorney and get in the game, you know, the chances are not, you know, they diminish as far as your success rate.
Right.
I know a lot of people that have gone in pro se and have done pro se litigation. In fact, I just saw a ruling out of California today on a specific situation where the plaintiff homeowner actually won a judgment. And it was not a default judgment. It was a summary judgment against Fannie Mae. And they couldn't prove that they owned her paper. And the judge literally quoted Carpenter versus Longan, that 1872 case that says when you split deed from note, it's a nullity. Some judges understand this. It's so simple. But other judges, we have to actually look into their financial records and find out whether they own any bank loans. We had a judge in Palm Beach County, Florida, that had a massive Bank of America portfolio, and basically her retirement was in Bank of America.
Right.
And so here she's sitting on all these Bank of America cases. Go figure.
Right. Well, and that, you know, after I'm looking at all this stuff today, Bank of America seems to be in the thick of this mess. They seem to be, my house loan, my current house loan, I didn't sign with Bank of America, but all of a sudden Bank of America is sending me the bill. So they're going out and reaching out and grabbing people's loans. I guess they're buying these mortgage securities that are out there, and then they're becoming the mortgage holder at that point.
Well, a lot of
how do they do that?
We're still looking at how they acquired these, because if the trusts went bust, if they went into default and the investors lost their money, what they're doing is, because of the fact that there is a 424B5 prospectus that is issued, and what this does is it contains all the information about the trust. You know, I call it a poop sheet. And basically, you look at it, it's got the PSA, the pooling and servicing agreement on there. It's got all the terms and the distribution date, tells you when the cutoff date is and when all the notes have to be in the pool, has a closing date for when everything gets finalized. It has a distribution date, which is usually 30 days after the closing date, when the investors can expect to get a distribution of funds.
Right.
There are, you know, anybody that's been playing in these things and realizes that they've been duped, if they're an investor, what they're doing now is they're coming back and they're suing the bank, and they're saying, hey, you lied to us on the prospectus, and we bought non-recourse bonds, which means they're powerless to come after the homeowner. They're powerless to do anything. All they can do, and what they've been doing, according to the research, is they've been going after the lenders and saying, hey, this, you know, the brokerage house is saying, this paper you sold us, this was fraud. This whole thing was fraud. You misrepresented, you lied to us on the prospectus. None of this stuff you're saying on this prospectus happened. And so what the banks are doing, who claim to be buying this portfolio, are giving the investors back their money at 10 cents on the dollar. Wow. And this is your 401k, folks, that went down the toilet. It's gone. And this is why you see, when you look at that foreclosure map, you see all of these shaded areas. that are just, you know, I mean, you're looking at 4 million potential foreclosures this year. When you look at that map for 2012, I mean, this is huge. When you take that and you extrapolate it and you run that map a little further into the year, you're going to notice it gets a whole lot darker.
Well, and I think a lot of this great area is probably government land.
Well,
most of that's government. Montana, a lot of that's government
in that area. There probably is a lot of government land, but the thing is that, you know, they control all this, and, you know, the banks, I think, are waiting and trying to stall off a lot of these cases. They don't want bad case law. What they're trying to do is trying to get themselves set up to where, because they think the government will jump in and rescue them.
Right. Well, and they have laws that they're trying to get written where retroactively they didn't do anything wrong.
Exactly.
At that point, we don't have to have chain of custody. We don't have to have the things that we've had in place since Plymouth Rock. All we have to do is say, well, it's okay now, we're going to wash our hands and move on.
And this is a problem, because the thing is that most states right now, this could come down to an issue between states' rights and all the county clerks that are running the land records. When I first shared this information with the Texas Clerk School in January, we had 200 clerks come to attend this out of the 254 counties. The second session, which they were only 50 minutes long, but it was MERS 101, and I was explaining how this whole system came about and the robo-signing and everything. And when we first started out, I had 100 clerks in the second session, and I said, who here has heard of MERS? 100 clerks in the room. 3 hands went up.
Wow.
3 hands. That's exactly the words that came out of my mouth. Exactly the words that came out of my mouth. I went, whoa! And then I said, how many have heard of robo-signing? 1 hand went up.
Yeah.
And I'm like, oh,
kept in the dark and the mushrooms.
You're in for a real treat, clerks. You're in for a real treat. The problem is that they don't understand the nature and scope of how deep this goes with chain of title. And one of the things that, you know, is now coming to light with a lot of these judges, a lot of them refuse to issue summary judgments and orders when the chain of title is not clear. And so homeowners literally, with their attorneys that have gone into court and said, we have an issue with chain of titles, it's put the brake on the entire scenario, on the entire foreclosure.
That's a good stall tactic.
Well, my mantra is, if I can't convey, neither can they.
Right. Oh, okay.
That's my mantra. Good. It's always been my mantra. I put it in the book. If I can't sell this property, Your Honor, then the problem I have as a homeowner is, if it's uninsurable, I can't sell it. Right. If a title company, like we had some inside information from one of the big title companies in Kansas City, that 1/3 of the properties that were mortgaged or refinanced between 2003 and 2008 are uninsurable. That means that they can't get title insurance and they can't sell the house.
Right.
If they can't do it, how can the bank? How can the bank turn around and foreclose and sell that property?
Well, banks are special. We have to give them money when they fail. You know, these are special creatures. These people need lots of money to live, all these bank executives. You know, and it's sad when, you know, one of the HSBC heads jumps off a building because he's probably involved in some fraud scandal funding Al-Qaeda. I mean, it's amazing that we coddle to the banks over and over again instead of actually holding their feet to the fire. These are rules that they're supposed to be playing by. Well, they're supposed to be the professionals.
And see, we have a lot of investors attending the CODA workshop. And by the way, you know, this is the workbook that I give you at the workshop. It's 200 pages, and we actually have in here case studies. We actually go into detail, and we show you the difference. We show you the stamps.
Here, let's get this. Here, we'll put this on the overhead cam right here.
So you can see this. You'll notice in here where we're looking at specific issues, and we actually show you how to read these document stamps and how they are formulated by index. And so, you know, we actually, when we put this thing together, we show you in the workbook how this whole thing is set up. And we show you in here, you know, what happens, and we ask you to look for certain things. We show you, you know, that it was a countrywide loan. We actually take you through the entire structure, and if you look right here, you'll notice a document ID number. But what's this?
There's your MIN number.
There's our MERS identification number, our 18-digit number. You can actually go to the MERS website and take this number and input it into the website at MERS, and you can actually find out who the servicer is, but only if you have your Social Security number. Now imagine that. How did MERS get your Social Security number? Well, when you agreed to make MERS the beneficiary, you gave MERS the permission to take your personal identifying information and run it all over Wall Street.
Oh my goodness.
Now who knew that? Who knew Who knew that you were going to get shellacked like this? And you know, frankly, the borrowers were never told that their loans were going to be securitized and put out into Wall Street. It's like the banks are saying, well, that's none of your business.
Well, you should get a percentage of that if they're using your money.
You would think that if the note was paid off in advance, that paid off money would be applied to the borrower's mortgage.
Sure.
That's not the case. So we have we have the scenario, the theoretical scenario, that they're borrowing money from the Fed, using investor money to pay off the Fed, so what the borrower signed and agreed to is paid in full. Then they're turning around and taking the investor money and investing it and pledging the same note over multiple pools, which if I did that and I pledged my house to several banks, I would be in jail. That's a felony.
Right.
You know, but the banks did this. They got away with it because they're unregulated. And this is when they repealed Glass-Steagall back in 1999 through, thank you, the Graham-Leach-Bliley Act. You know, if you want to go in there, and I can tell you that Phil Gramm right now, you know, if I was Phil Gramm, I wouldn't be making any comments about, you know, what their intent was, because this is getting uglier by the minute, and homeowners are starting to rear their ugly head. And the more and more people that read this book and start talking to counsel and start researching their land records. I actually, when we did the CLE in Austin in May, Rob, I had investors attending this workshop because they're studying these things. Before they go in and buy a house, they want to know what the chain of title looks like. And so they're studying condition of title.
Right.
They don't want to make the same mistake, because if they buy an REO or a short sale that lender doesn't own and subject themselves to double liability, or in the case of one of the buyers, she paid cash, $60,000 cash for a house on acreage, and come to find out, the lender didn't record their interest in the property till 9 months after they gave her a special warranty deed. She didn't legally own the house. Wow. That's the take by the attorneys, and the attorneys are going, we can't quiet title. You don't own the property. You can only quiet title if you can prove you own it. So she has a whole different set of circumstances. This is how nuts this is getting, and that's why, you know, I'm encouraging people. I have a very limited number of seats at Chicago. Get in there and take this workshop and get the knowledge. Knowledge is power. And if you don't get it now, you know, we don't know when we're going to do another one because we are so swamped with work. Right. I literally am training people to do what I do to share the money. Well, I mean, because a lot of people are broke.
You know, you got potential 4 million people out there that could use this information. Well, or 4 million homeowners.
Well, but you've got 70 million titles to property that have potential clouds on suspect issues on them. So you have 70 million potential problems that, you know, what do we have? 100 people maybe in the United States that do chain of title, if that. Yeah. I mean, this is literally an open floor plan for anybody that is creative. And we actually teach you in the seminar how to market yourself and get yourself out there, and how to network with attorneys and get in good graces, and how to understand what constitutes unauthorized practice of law. Because the last thing we want is for the state's UPL committee to come after anyone because they said something they shouldn't have.
Well, and you put that in the book. You put, you know, this is legal information. It's not legal advice.
That's right. You can't. I can't give you legal advice. I'm just a paralegal and a journalist. Right. But, you know, I've talked to enough attorneys, and I put what they said in the book. Because what the attorney tells me is one thing. What I find in research is something totally different. And I basically leave it up to counsel. There is a forward in here by the former Ohio Attorney General, Mark Dan, who is in my network, and we talk a lot. Mark Dan and I have spoken on stage together in front of crowds of homeowners, and I'll tell you what, that man is like a magnet. I got a phone call yesterday from Taj Johnson, who's another attorney in Chicago. This guy's unbelievable. He studied at University of London in London, you know, economics. Okay. The guy's incredible. Yeah. You know, when you look at attorneys like him and the attorney I work with in Dallas, Wade Cricken, all these people are putting themselves at risk because the banks don't like people that come out. In fact, one foreclosure mill tried to hire the attorney I work with in Dallas. They tried to hire him away. Sure. And they'll literally, they will come to you and they will pay the attorney off so he'll never litigate it against him again. Right. This is how they do this. They're not beyond this.
Yeah, of course not. I mean, you know, most of the drugs